what is reasonable doubt? And is it, can you have reasonable doubt, or do you have to go beyond reasonable doubt? So, you first.
I think reasonable doubt was really illustrated well by what you just watched, where some people know very well what it is. It's a question in their mind, it's a question linked to the evidence, it's a question linked to something in the way that the narrative played out. But I think you saw how it evolves. It's not always something that is known 100%. It's really a personal thing, and you can be persuaded or you can change your mind. And that is, I think, the idea behind having juries and having this kind of discussion, is that you want to have an open conversation. And with the reasonable doubt or the beyond a reasonable doubt is, we don't want to take lightly that we're putting someone in jail or in prison, or putting them to death in this case. And so you want to be very careful with how you're considering the circumstances surrounding something, the evidence that's presented. And I'll kind of stop there. I could keep going, but lots
Bryan,
to say.
would you like to add something to that?
So, in my time as a lawyer, I've thought about this question 1,000 times, because you have to try to address the issue with jurors in a way that doesn't redefine the law for them, okay? The law is the law. Reasonable doubt are two words that have meaning. Reasonable, doubt. Okay, everybody knows what doubt means. Everybody knows what reasonable means. It's how it comes together in an individual's mind. I've seen it redefined a couple of times. I used to practice in Massachusetts, and there the jury instructions would offer a couple of other explanations. One of them being what was it? Well, I'm forgetting it, but the Arizona one is a firm conviction. But to me, a firm conviction is two different words than reasonable doubt. So I think that it should just be the words and what their meanings are, and whatever the individual concludes that they mean for them.
Okay. Questions? We take questions from the audience here. Or anybody else want to comment about? Yes, Sel.
I think that why some people may have jurors in the position of having to make that decision, why they might stumble or hesitate on the idea of reasonable doubt is that they're thinking that if they say reasonable doubt, it sort of automatically means innocence. And they're not the same thing. You can have reasonable doubt, but that doesn't necessarily mean that the person is innocent.
And it goes back to that one question about the lawyers. The lawyers can't think of everything. Questions? Raise your hand so I can see it real high. Okay, right over here. Thank you. What's your question, please?
I was involved in a jury process at one point, and we were told not to think about what the sentence was going to be, that we were just deliberating on what was going on with the person, whether we thought they had done it or not, beyond a reasonable doubt. And in this play, it seems to indicate that the death sentence has already been carried out. But do we think that's maybe just the dramatic effect that it could potentially be carried out? And is that realistic? And was my jury wrong?
Well, one thing I want to say about this play, this was written in 1955.
Yeah.
And a lot of the language is carried over from there, not really modern.
Sure.
So I think a lot of that legalese might be from them.
I can't answer that question for you, though. Generally, you're not supposed to consider punishment, because it would sway your evaluation of the facts. But when it comes to the death penalty, the jury actually has to determine whether or not they're going to put this person to death. So you have to identify it as a death penalty case during the jury selection process, so that all of the people who end up on the jury are capable of making that decision.
Really interesting. Thank you.
And I think that was a Supreme Court decision that confirmed that a death penalty case has to go to a jury, because again, the importance of having a jury of your peers be tasked with the weight of that decision as opposed to a judge or a single person. That was my understanding.
And frankly, it's something that gets considered in the charging process. So crimes are not automatically death penalty cases. The elected, in this case, county attorney has to decide, are we going to allege death in this case, or are we not going to? And whether or not you think it's realistic that a jury would put somebody to death is somebody that is something that comes into that consideration. So there's a million variables. It's obviously the most serious possible penalty. And frankly, there are cases where you don't want to risk a not guilty finding because the jury simply didn't want to put the person to death. So you will elect not to allege death in that circumstance.
Good. Anybody else want to comment here? Question, right over here,
Well,
folks.
I just want a follow-up question on that. Would that infer then, is that a justification for say, the prosecuting attorney, if somebody said, I don't believe in the death penalty and I will never, I might convict somebody, say they're guilty, but not if I know they're going to death, and then they would be eliminated from the jury? Is that?
If it's a death penalty case, a person could be eliminated for saying that they cannot put somebody to death. But there are also people who say, I can't sit in judgment for anybody, so say for religious reasons or for whatever. So there are people who, because they can't follow the law, would be eliminated, could be eliminated from a jury.
So on the flip side of that, if you get someone who's like really pro-death penalty, would they end up being eliminated as well?
It's actually a really interesting question these days because very recently the Supreme Court in the state of Arizona eliminated what they call preemptory strikes. Okay, so in jury selection there are preemptory strikes and there are strikes for cause. Strikes for cause are somebody said they couldn't follow the law, somebody exhibited a bias during their jury selection or whatever.
Suzanne.
Preemptory strikes are those strikes that the lawyers just get to use without having to explain themselves. Now, depending on what kind of case it is, each lawyer might have 2 preemptory strikes or 6 preemptory strikes, but they've recently been eliminated. So that means that it's going to be up to the judge to decide whether or not somebody has exhibited cause. And then you can ask what cause means that they shouldn't participate in this particular jury. So that just happened. We'll see how it goes going forward. It could play out to be good for the defense or bad for the defense in any given case,
Okay. Questions? Any other questions? Right here, please.
I just want to make sure I understood you correctly. Did you say that just recently the Arizona Supreme Court or whoever said there are no preemptive, so lawyers don't get to say, we don't want this person on the jury?
There's no peremptory strike. So what that means is that the lawyers can't strike somebody without there being cause on the record.
Okay.
And the record being the form they fill out when they become a jury member, right?
No, the record is just the
Selection.
transcript of the entire trial. So
Oh, okay.
it just has to be, the judge would have to make a finding that there was cause to eliminate this person.
Okay. I have a question.
Can somebody just get out for saying, oh, I'm, against the death penalty without like any proof of anything?
Yes, I mean, it's ultimately you have to take people at their word. There's no way to prove otherwise, and frankly, as the prosecution, trying to convince people, I'm not going to beat somebody up during jury selection and try to prove that they weren't telling the truth, and then have them on my jury.
You have a question?
Yeah, so you had mentioned this was obviously an older play written, I think it was a book first maybe. To the cast and directors, what did you guys change from that? Like if I remember correctly, it was a more racialized version when it was originally written, so like what do you change, maybe why did you change it?
Well, so the author served on a jury, and this was the impetus for him to create this play. And as Mark said, it was, I think 1954 was the movie with Henry Fonda.
Oh, that was a television show first.
Yeah,
And
that's right.
then the movie came out in 59.
Right, and then there was another movie with Jack Lemmon, and
Yeah.
I think there was even a female version. So Then they created this play, 12 Angry Men. So then it became 12 Angry Women, and then it became 12 Angry Jurors. So there's been a lot of truck on this particular play. And it's, as was said before, it's been done all over because it has these universal aspects about it, you know. You know, one thing I'd like to mention here, what really motivated me as I was doing research for this play, is not only from the law, not to take away from the law, but what an incredible lesson for all of us. Now, there's a lot of students here, and at the university, I know you've all been hearing about critical thinking. A lot of critical thinking. And so what this character does in this play is so fundamental that could be so helpful, I think, to all of us as we get into arguments, that someone says something and, you know, most of us say, I don't agree, and then the argument goes on and it goes nowhere. This person was a master. She says, I don't know. I'd like to talk. And she's constantly saying, you're right, maybe, could be. And she's a master, this character is a master of negotiation. She wins allies. She does improvisations, you know, to mark things out, and keeps building consensus for her argument. And eventually, she wins through this communication process and not being subject to the insanity that we're living in today, you know. You know, hypothetically, I just give you hypothetically. Let's say somebody was running for office and they said, you know, everybody crossing the border are murderers and rapists, you know. I mean, you know, something so basic as that, and yet no one said, well, how do you know? Or what data do you have? Or what evidence, you know? And, you know, 3/4 of the country agree. So, critical thinking.
Anybody else?
I'd like to comment on the language, because I did have issue with it, especially my character. I feel like my character uses ableist language. I do not feel like a woman in my position in this world would use the word like dumb. It's an ableist word. I feel like it does need, or also the fact that I probably committed a felony or at least a crime by bringing a knife in this apartment.
We would have to let you bring that knife then.
Yeah, so I mean, there's things about it where you think it really does need some modernization, but I think Bob it hits it on, you know, the head. It is a play about more than just setting it in modern times is a whole nother. I think it hit me yesterday, the irony of this play in this time that we live. Anyway, so yeah, there are things that it really needed to update if we wanted to be 100% accurate about the times in which we live. So.
But it is a play.
It is a
Well, if there were some lines with BuzzFeed
yeah, we
and
updated
blog.
a couple of the
Yeah.
references.
Okay.
I had a little bit of fun. My character is described as dull-witted, so I went with Valley Girl. Sort of an updated version of, you know, who this character might be in sort of a more modern setting.
You're so basic. Emily.
Wishy-washy.
Other questions? Don't be shy. Okay, well, I have. Oh, you have one. Right here, please. Thank you.
So, it's kind of, I mean, it's not a deep question at all, but I was wondering why they decided to make that one character have a cold. Like,
Oh,
was
yeah.
that anything? Or
Chris is here.
Is that original?
No, it's in the play.
That's in the play. That is a good question.
Yeah, I think the playwright was just trying to show the humanity of each of the characters, that this is just he had a cold, something very, very normal. And there's a lot written on each of the characters, you know, I don't want to bore you with that, but, you know, number 3, she has some kind of problem with her son, you know. Number 5, you know, she did live in the slums, and she carries that, you know. Number 12 is in advertising, kind
I'm
of.
an advertiser.
kind of a schmuck, you know. But he doesn't know anything, you know. Because there are several times. What do you think? Oh, I don't know, you know. And so you see how this incredible group. Some people approach the play with just the people saying, here are these individuals and they just come in and fight it out, you know. But I think there's something much greater to go after in this one.
Now, me to another question about the dynamics, the group dynamics in a jury. You know, if you could talk about that, I mean, what happens if there is a fight? Does that happen often? Do they recreate the crimes? I mean, what's your experience?
I mean, I think there's a lot we don't know, because it's a closed room, and you have a bailiff who, you know, can come and assist if things, if they need evidence, or if they need to look at something, or if they need to take a break. There's sort of those kinds of structures that might be built in. But I think a lot of what people think they know about juries comes from, you know, fiction, comes from what they see on TV, comes what they see in movies, and I think the reality is that it's probably not quite as dramatic as this. And I think, you know, it's uncommon that you see kind of an 11-to-1 vote swinging entirely in the other direction. I think it's like less than 10% is kind of the numbers I've seen when you have kind of that really early vote that happens, to see such a swing. But it's also uncommon to see a really early vote like that. I think in a case like this, I think you would see much more discussion and talking happening. That's just kind of what I know from the research, but again, the research is also very limited. It's not the day-to-day experience. I'll say one more thing. I myself served on a jury many a year ago, and it was, you know, it was comparable in the sense that it had people from kind of all walks of life. But it was much more skewed to have people that had availability. So I was a graduate student. There were a lot of retired individuals who were on the jury. And so you tend not to have people who are working and can't take time off work. They might fear that they're going to lose their job. And so they're, you know, the idea of a jury of your peers where you're going to have full representation and all the diversity of opinions is maybe not entirely accurate, because you tend to have people who have kind of biographic availability, that they can spend the time going and serving on a jury. So.
Anything to add to that, please?
I don't get selected for juries. I don't know where
You are
things
striped for cause.
That's right. But I would say that there probably are heated arguments that take place in jury rooms. I've had cases where it was 11-to-1 for guilty, and one person just went in there and refused to deliberate. So the rest of the jury just deliberated for 3 days, and this one person refused. So I got calls from those jurors afterwards who were beside themselves, because this other person just wasn't doing what he was supposed to do as part of his jury service. So there's definitely heated exchanges in there.
Is there any potential sanctions for somebody like that or not?
No. I mean, you have a right to take the position you take in the jury room. So, but I would say, you brought up your jury service, and oh yes, availability is definitely a big piece of what goes into who makes it onto juries. Is those people whose jobs are, you know, you can take a little bit of time off. For example, generally, NAU professors don't make it onto our juries because they can't not teach for, or 2 weeks. Their classes suffer. But this is what I'll say. Please don't use excuses to get off of juries. We need smart people to stay on juries. People think that they're smart by getting out of there, and that's unfortunate because it leaves the people who weren't smart enough to get out of juries. We want those smart people.
Back here.
So can you volunteer then, or do you have to be solicited?
That's a great question. Generally, the jury pools are selected from like the voting rolls and the DMV rolls. I'm not aware of a way of saying I am available for jury service. Please choose me. I'm not aware of it.
No, but you can call and just check that your information is up to date, because sometimes you think it is and you just assume you haven't been called, but sometimes there's like a hold on your account as like they're waiting for you to turn in a jury solicitation that they thought went to your address and maybe you never got it. So you can certainly put a call in and just say, hey, just checking that my information is current. And
I would second Bryan's comments. I've sat on one jury, I've been through the questioning process many, many times, and I've only been chosen once. And it was a very, very interesting process. Unfortunately, at the end of it, I was one of the alternates, so I never got to get into the deliberation. But this was several years ago here in Flag, and part of the process, at least at that time, was that for any given witness, after the two lawyers get done with them, then there's an opportunity for the jury to ask questions. You submit your questions, there's a sidebar conference to decide if any of the questions are appropriate, and if they are, they get asked, and you're told, don't make any judgment of the fact that your question wasn't selected to be asked. But you do have a chance to actually you may have a chance to actually get the question answered that you think is really relevant, and you think you need the information, and you probably do. So, if you have the opportunity, and you're not in the middle of taking classes in the semester, I understand that's a problem.
Okay, have a question up here?
Do you see a trend over your career, more hung juries, less hung juries? You see that kind of ebb and flow, or how do you?
It's difficult for me to say. I started out in Massachusetts, and I always say, I'll take a Massachusetts jury over a Coconino County jury every day. So I would say, ultimately, when I moved here, after I kind of saw how the law functions different, the rules are different, and so forth, it all kind of shook out the same way. Frankly, I think in Arizona, a ton of resources are poured into every trial by comparison to Massachusetts, but it shakes out the same way. So I would say yes, I would say a trend of people being more contrarian, less willing to kind of agree with each other is becoming a greater problem in terms of unanimity in jury verdicts.
And I just would like to add that it's still much more uncommon to go before a jury than it is to end up in a plea agreement. That's the much more typical criminal justice process.
Something like 97.5% of cases are resolved by plea.
Yeah, so when,
versus trial.
and often that can involve too, where you go through the jury selection process and you're about to kind of go into the courtroom and the plea deal is struck right there. Like, I mean, not often, but that does happen in that, the pressure of having to go in before a jury can be that kind of final straw that makes someone accept a plea agreement. So I've heard that happen a few times recently as well. So.
Just a little sidebar. I went over to the courthouse and I met the bailiffs, and I never talked to them, And so I said, in the play here, the bailiff leaves and locks the door. I says, do you guys do that? He says, no, we sit right with them. So that changes the whole thing, but we decided to go ahead and do it.
Question right here.
So especially considering today's world and circumstances, are there steps to be taken or things to consider to make that ideal of a jury of peers more apparent, more realistic?
Rather than a jury of people who are available.
Yeah, is that, are you asking, I guess, about the plea versus, jury trial, or?
Just so that idea that you're judged by a jury of your peers, whether that be economically, a social aspect, a racial or ethnic aspect, how that can be more complete.
Yeah, I mean, I think it's a really hard question to answer, what are the solutions, but I think we see a lot of good work being done in criminal justice reform where, it starts at the level of policing through, prosecutorial decision-making, through, the guidance for judges in the courtrooms, the guidance that are issued to juries. In terms of, public defense, and is public defense being funded well? Are there cooperative kinds of relationships between communities and the justice system, or is there a real division where the criminal justice system actors maybe are not in touch with what's happening in their community. I think, you look at a community like Flagstaff and you see lots of real, I think, strength and community engagement by a lot of different kinds of people in the justice system, and there's good awareness of, mental health issues, juvenile justice issues, housing issues. I mean, you sort of see a lot of those race, class, gender, religious, like just all the kinds of differences that people have, I think are considered in a smaller community. It's a little bit easier to kind of notice that. When you have much larger cities, I think this play takes place in Chicago, is my guess, by the references. And, when you have larger cities, I think it can become much more complex and much harder for that kind of individual community member to kind of hold them accountable, but you see a lot of good efforts that are happening at that level. So, I don't know, Bryan, if you have specific things from your perspective?
Well, the only thing I would say is that you don't have a right to be judged by a absolutely representative cross-section of your community. You have a right to be judged by your peers, and those people that end up on your jury are your peers. So I consider the ideal to be impossible. But I think that most juries are objective people who are weighing the evidence and are not motivated by significant bias. I mean, I think everybody suffers some bias. I think it's foolish to think that anybody leaves their bias completely at the door and comes at it completely objectively. But we're not talking about an even, it's not a basketball game where both teams start at 0 and whoever wins, wins. The prosecution has to prove that case beyond a reasonable doubt. The defense doesn't have to do anything at all. So it's a really tall order in order to convict somebody. The criminal justice system is set up so that innocent people don't get convicted as a general principle. Like the words that used to be thrown around is, 1,000 guilty people go free before an innocent person gets found guilty. The rules are set up that way. They really are. There was one comment in the play about the defense attorney not thoroughly cross-examining, and that's actually one of the issues that comes to lead juries to the wrong conclusion, is to make assumptions about what the attorneys should have or should not have done. Because the truth of the matter is that the jury only knows what they were given, and they were only given that because the rules exclude a lot of information. So a defense attorney might not ask questions because it would open the door to a whole bunch of bad stuff about their client that the prosecution can't get into unless the defense opens the door. So judging the attorney's performance is going to lead you down the wrong road. That's just a fact.
I have a question.
I have a comment.
Sure, please.
Just listening to all of this, it makes me think about how much of a personal growth process being on a jury is. Because you might be somebody who is more emotional than mental, or more spiritual, or that you have more tolerance, or you have some prejudice, or you have, history with crime, or somebody got killed in your family, or injustices in other ways, so you either come in, as a really open, neutral book, or your responses are based on your inherent nature, so you might, really not give up on a point because you feel like that needs to be figured out and answered, and I want it right now, and you get angry and frustrated and whatever. Or you could be somebody who is a good listener. Somebody who's not a good listener, you might miss a whole bunch of it, but you still have your mindset, and it's fascinating. There's so much opportunity for people to grow and to learn and to see themselves, but most people are not that aware to really do that.
Chris, do you have a question?
I have a theatrical question. For jurors 3 and 8, what did you think of your characters?
Mine's not the best, but but I think just like what you were talking about, Toby, it's, you know, the personal reflection, whatever, and really going inside yourself sort of at the end, and she did come in with baggage, emotional baggage, her son. But as far as playing the character, I was fine with it. It's not my thought process, but it's a story that needs to be told. So, what do you think?
I admired her. She's much more cerebral than I am. I emote much more than she does. So it was very difficult when they're all hating on me. I have to say I did have a very emotional response on the inside. Because, I mean, one of the themes is about, you know, it takes a lot of bravery to stand alone. I was doing it for 10, and it was difficult for me to do. Because I think they're just, you know, it's our little lizard brains really just need to have that acceptance of our peers and our groups that we're in. And so I learned a lot from doing this role about communication and about arguing, actually. So I hope my husband appreciates that.
Anything else before? Well, let's give, you have something?
Yep, we're good.
Okay, well, let's give some appreciation. And thank you all for coming and supporting Theatrikos. That's very important. Thank you very much.